Welcome to Amplifying Recruitment. With the incoming Employment Rights Bill, we're about to see the biggest legal changes in our industry for 30 years. In this episode, I'm joined by Simon Bloch, who is a specialist solicitor to the recruitment industry. This is a short, sharp episode to give you some insight into what you need to know about the incoming changes. Simon, welcome to Amplifying Recruitment.
Thank you very much. Thanks for having me.
If anyone has clicked onto this and gone, it's going to be some boring legal jargon crap, in like 30 seconds, just explain to those people why they need to listen to this episode.
Yeah, the changes that are about to be implemented through the Employment Rights Bill and the changes to the legislation affecting how umbrella companies operate are some of the biggest changes that I've seen in recruitment for the whole time that I've been practicing. I've been practicing as a lawyer for nearly 20 years now, and these changes are significant, they're relentless, and they will affect how you run your recruitment business.
And they're going to affect recruiters like on the ground, at the coalface, on the tools as well, aren't they?
Absolutely. The changes that are coming about, there's 28 areas that are affected in terms of the Employment Rights Bill. Okay. Most of them relate to trade unions, but some of the biggest things that are going to change relate to changes to how you operate 0 hours contracts, which, for the avoidance of doubt, definitely does include agency workers. There was some debate for some time whether agency workers would or would not be in scope. They are definitely in scope. We've got changes to unfair dismissal legislation. We've got changes to statutory sick pay. And we've got changes to the laws relating to, it's described as fire and rehire, but it's really fire and re-engage, and I'll explain a little bit about that as we go through. It's huge, it's significant, it's relentless, and if you're not prepared, you will get left behind.
Like, how do you normally introduce yourself to people in 30 seconds? Like, what's your...
So my name's Simon Bloch. I'm a partner at JMW Solicitors. We're a national law firm, top 100 law firm based in Manchester. We have a sizable office in London, a small office in Liverpool. We're a full service offering, but I specialise in employment law, and probably for around the last 15 to 20 years I've specialised in advising recruitment businesses of all shapes and sizes, sectors. I advise big national and international global recruitment companies, and I also advise startup businesses as well.
So, in really simple terms then, from someone that's entirely ignorant when it comes to this stuff, what is the Employment Rights Bill and why should a recruiter care?
Yeah, so let's have a little bit of a history lesson. Let's go back to general election in 2024. The Labour Party got into power. They proposed in their manifesto that they were going to change how the world of work worked, and they described it as the plan to make work pay. In their manifesto pledge, they said that within 100 days, you will have an employment rights bill. And they did not fail to deliver. Within 100 days, last October, they developed an employment rights bill, which has massively evolved in the time from the original bill, and has proposed a huge shake-up to how the world of work is going to work. And the examples that I quoted to you before just show you how big those changes are going to be. Just in terms of where the legislation is up to, it's currently ping-ponging between the House of Lords and the House of Commons. It's back in the House of Lords on the 17th of October. They're debating a number of points. 17th of November.
Yeah, and I suppose for context, that's really important. So for context, we're recording this on the 12th of November. So by the time this goes out, we would have had that bit. It would have gone back.
It would have gone back. And if they can't agree, it could continue to ping-pong back. But there is a piece of legislation that is known as the Parliament Act, which has rarely been invoked, where the House of Lords the House of Commons as an elected chamber could say, well, we're elected, we're getting this through, but I can't imagine that they want to do that. So they want to try and get the Lords to back down. So
with all this that's coming in, what's the first thing that you think is likely to affect a recruiter or a recruitment business owner? What do they need to be most aware of?
The government released a roadmap back in July. There are lots of things that will come into force come the bill becoming enacted. But many of those relate to significant trade union reforms, and I'm not really going to talk about them because we'll be here all day. The biggest thing that is coming about from April 2026 is the changes to how the SSP regime will operate. And if you're a recruiter, you operate a temp desk, you pay your workers, then SSP is your problem. And therefore, the change that's going to come about will be how it currently works is that somebody's not entitled to SSP until they've had 3 qualifying or waiting days. This legislation means that from day one, a temp, a worker, an employee is entitled to be paid statutory sick pay. And the reason that the Labour Party did that was during COVID, they saw all these people not working, not being paid till they'd had a few days qualifying. And they said, we're going to change that if we ever get into power.
So, I'll be really clear here. I'm a contract recruiter, and I've been a contract recruiter for a long time in lots of different markets. I worked in education recruitment, right?
Yeah.
And so if I've got one of my regular clients, they phone me and they say we need a supply teacher for tomorrow, and I go, right, who's my teachers that I can always rely on that are really good people? And I phone Sue, and Sue's worked for me for ages, and she's been out loads of times before, and I book her in for the next day. But on the morning, she phones me and says, I'm feeling unwell, I've got a stomach bug. Now, typically, I would have just gone and found another teacher and booked them in, and I still make my margin. But you're saying I've still got to pay her, and I've got to book someone else in, and I've got to pay them.
Yeah, so in theory, absolutely. If somebody's in the middle of an assignment and they're working, and then they say, no, I actually can't work because I'm sick, they're entitled to SSP for that period of time.
Say I've got someone that's, I don't know, they finished one assignment with me, and then I book them into the next assignment to start on Monday. And on Monday morning they go, no, do you know what, I've had too much to drink on Sunday night, don't fancy this. And they just don't, and they, no, I'm ill, sorry Jamie, I've got to pay them. And
this is the real risk that we've got to grapple with, and the regulations. Remember, we've got an employment rights bill which will become the Employment Rights Act 2025, and regulations will give effect to how this is going to actually operate on the ground. But you're exactly right, there is a risk that you get a malingering employee who just thinks, I'm going to play the system here, I'm just going to call in because I've had a heavy night on that Sunday night and I'm not going to come into work. That is a current risk that SSP will be payable from that first day. I think that's how we have to boil it down at the minute. We've got the qualifying days will be repealed and SSP will be payable from day one. And I think the other thing to also remember, which may affect how agencies work, there are lots of people who are not entitled to SSP because they earn below the lower earnings limit.
Okay.
There are qualifying earnings that you've got to get to be able to get statutory sick pay. That's being removed. So the way it will currently work is you'll get the rate of statutory sick pay, or 80% of what your pay is, whichever is the lower. The current rate of SSP from April 25 was just short of £119.
Wow, okay.
And that's not recoverable. You've got to pay it.
And we can't pass that on to the client?
You can make contractual arrangements in terms of how you structure it, but it's your liability as the agency to pay this amount of money.
So this is anyone running a temp or contract desk, they're kind of on the hook here, aren't they?
Yeah, absolutely.
So 0-hour contracts then, what's the impact there?
This is huge for recruiters if you're running a temp desk. So when the Labour Party got into power, these were all described as 0-hour contracts. They're exploitative. That's quite a hard word, you know.
Well, some people want a 0 hours contract.
Yeah, and that's the problem, because the Labour Party decided that all 0 hours contracts were exploitative, but they perhaps forgot about the recruitment market, because you just cracked the nail on the head. Some people actually really do want to work in this way. It suits their life to contract in this way. But I'm afraid agency workers are very much in scope for this legislation. And let me just give you a quick précis of how it's going to work, because I think that's important for listeners to understand. So there will be an obligation to offer for an end client to offer a contract to the agency worker that reflects the hours that they've worked over what we expect to be a 12-week qualifying period. Don't have that guaranteed, that 12-week qualifying period, or as yet, but that's what we expect in terms of the legislation. That's the starting point. If the worker accepts that contract, a direct contract will form between the worker and the end user client. So you're getting recruitment and turning it on its head here, aren't you? Because that's not how agencies want to operate. Agencies want to supply a contractor because it works for the flexibility of the regime so that you can control your workforce, especially during periods, well, we're coming into peak periods for some businesses now, running up to Christmas. So that's a good way to control it. So you can see there's an obligation to offer. There's not an obligation on the worker to accept. The worker can turn it down. And this is one of the things that is being fiercely debated at the minute as to whether or not there's going to be whether the House of Lords are going to get their way with this.
The offer piece is one bit, right? And I think there'll be plenty of. I'm just thinking about like hospitality, right?
And
as we ramp up to Christmas.
Yeah, exactly. So the way that this is conceived was that things like hospitality was considered to be a sector where 0 hours contracts can be very much abused, as well perhaps as sometimes in the NHS. You think about it, somebody's offered some work, they pay for childcare, they pay for transport, they get on the train, and half an hour before they say, actually, we didn't really need you at 9 o'clock, we needed you at 2 o'clock, can you come back then? That is what this is designed to stamp out. But the problem is that the effects of the legislation go much wider. Yeah,
and I know we're not here to debate the politics or the rights and wrongs of it.
Yeah.
And for what it's worth, I do think it's wrong. I'm not sure that's the answer, but we're not here to talk about that. But like, so what happens now then? So obviously the worker can go, no, I don't want a
and they
contract
carry on.
With.
So they carry on working as a temp, but they have to keep reoffering it. So there's this reoffering.
How often?
Piece throughout that period, throughout the qualifying period.
So like, is it every day? Every 12. Simon, are you sure you don't want a contract?
They will set that qualifying period out.
Okay, so I suppose that's one thing, isn't it? And I expect we'll get a lot of that. We'll get a lot of temp workers that go, do you want a contract? No, I absolutely don't want a contract. This is why I choose to gig this way. I suppose the danger is, as an employer, I go, gosh, I've got to offer these people a contract. What if they say yes? Because I don't need you.
And that's the hugely difficult point, isn't it? If they say yes, you've got to accept them, which is where the skill is going to come about with the agency working with their client to consider these needs and make sure that an end client does not run the risk of being overstaffed. Because you can think about it in this way, is that if people are saying, yeah, I want to take that contract and have some certainty and work directly for the client, you can end up with a end client having massive overstaffing problems, and the agencies inadvertently cause that.
I'm just trying to get my head around this from a real practical perspective. If I'm head of staffing for nurses within an NHS hospital, and I said, you know what, I need 3 temps tomorrow. I need 3 temp locum nurses in tomorrow. I've got to offer them all a contract.
What? Just if you're talking about that on a
so like
temporary basis?
Yeah, I need them in for a week. I need 3 people for a week. Have I got to offer them a contract?
They've got to be working for a qualifying period.
I'm sorry. Okay, right. So, and what is the qualifying
period?
So
they were expecting that this qualifying period to be 12 weeks.
So if I keep that person for 12 weeks, that's it. Then I have to offer them.
You have to offer them a contract that reflects the regular hours that they work. So a contract that reflects the hours that they worked whilst they were being supplied as a temp.
Then I think this is going to lead us into another thing then. So if I don't know, I'm hiring a web developer and I think it's a 4-month contract, I go, I'm going to need him for 4 months. I'm going to change that, aren't I? And I'm going to go, well, actually, I only need him for 11 weeks and 4 days.
Yeah. And I suppose then the risk that is going to come about by this legislation, and there are going to be provisions in there, is that if you're structuring assignments in a way to anti-avoid the legislation, think about how the agency workers regulations used to work at the time, where you structured assignments just to avoid the effects of somebody getting qualifying equal treatment, this is going to have similar hallmarks to that legislation.
There's the SSP piece, the 0-hour contracts piece. Is there anything else you need to be aware of?
Yeah, in relation to 0 hours contracts, the other things to be aware of is there'll be a right to reasonable notice of cancellation of shifts. Right. We don't have a definition of what reasonable looks like yet.
So that's your thing you're saying where send them at 9, actually we don't need you till 2.
Yeah, exactly. So there's that, and then that's a joint liability. So they're going to say you're jointly liable for that, agency and client. But the big thing for agencies is they're on your payroll, these temps. And if there is a short notice cancellation of a shift, the agency has to pay them for that cancellation.
Okay.
And that is quite big for an agency. And if you don't have the right mechanism in place with your client to recoup those costs, you're on the hook. And also, good luck to you as an agency trying to say to your client, you pay me back the money if there's a cancellation of a shift, because there'll be somebody else down the road who won't be doing that, and they'll just move the business. So this is going to be a massive change in the lie of the land.
If anyone's listening to it, well, people listening to this as a recruiter or recruitment business owner, what's the immediate stuff they need to be start putting in place now?
Yeah, in relation to
for 0 hours contracts,
0 hours contracts.
SSP,
I think that in relation to those two issues, I think the big things that they should be doing now are, one, making sure that you understand what is going on. Making sure that those who make decisions are educated into this. This is a change, if you just think about it, that won't come into effect till 2027. And I said at the very beginning that this is the reason that they've allowed this amount of time is because they know how difficult this is. So 2027 is actually not that far away. But if you're not thinking about this now and how this operates and talking to your clients about how this is going to operate and affect your operation, then you're going to get left behind. Engaging with the client and not just forgetting and putting this to the back of the pile is going to do you no end of good with your client in terms of saying, I know what's going on, I know how the law is going to change, and therefore we need to have a sensible conversation about how this is going to operate. I think once you've done that and you've educated your staff, you're in as good a position as you can be for when they introduce consultations about this, because there will be consultation about how this will operate on the ground. And if you're going to do anything, make sure you input into those consultations. They do listen.
Yeah, I think, and I'll come back to that because I think there's a really interesting piece about the client communication bit. Can I open up another can of worms here?
You can.
So the thing that I keep hearing about, lots of people are talking about, is the changes to umbrella and this joint liability or joint and several liability. What does that actually mean?
Well, I think we just need to understand the concept of what joint and several liability is. If you think about this in the context of an agency who works with an umbrella company, there's been lots of bad press over the years about tax not properly being accounted for.
And that was a real thing as well, wasn't it? I've seen that firsthand.
Yeah, absolutely. And HMRC have been grappling with this issue for quite some time. And the concept of joint and several liability means that if, for example, an umbrella doesn't meet their tax obligations in terms of accounting properly for PAYE, national insurance contributions, then the relevant party closest to the client will be liable. So if you think that in the really most simplistic chain where you've got umbrella, agency and client, the agency will be on the hook if the umbrella doesn't account for it. And it is a strict liability. There is no defence to this. If the tax is not paid and the umbrella does not meet their obligations in terms of accounting for it properly, they will come to you as the agency looking for that tax.
So what advice do you give your clients? What advice do you give them about how and when they engage with umbrellas? Are you saying just use 20 different umbrellas because then you reduce the risk, like mitigate the risk because it's spread, or do you pick one that you're really confident in? How do you?
I think you've got to be as clear with who you use as suppliers now more than ever before, and in terms of understanding the due diligence that you're going to go through with that umbrella to make sure that they are compliant. You're never going to get an absolute ironclad guarantee, but there are various things out there that I would say agencies should consider. Firstly, there is the FCSA. They're an accredited trade body who audit their umbrella companies, and there are various other pieces of software kit out there in terms of checking payslips. Okay,
so I'm going to be really, really clear on who I'm using. I want to have some sort of auditing processes. I want to be checking payslips. I want to make sure umbrellas have got the right accreditations. Is there a risk, and I don't know the answer to this, that you could get in trouble for past discrepancies? So, for example, I was using an umbrella 3 years ago, and they can.
I'm no tax expert, but in terms of retrospective challenges, I think that would be pretty unfair.
Okay, so this isn't like the new PPI, right?
This isn't. I don't think this is going backwards, but I think from when this legislation comes into effect, you have to have as an agency, you have to have your arrangements absolutely on the button in terms of making sure that the tax for your workers is properly accounted for. And there's a risk. I've heard people talk about risks. If there's no umbrella in the chain and you're actually, because they're going to change the definition of what an umbrella company is. That's out there. And if you're contracting directly with a client, you've just got to make sure that your tax, how it's accounted for, is absolutely on the money, and that there's no wriggle room for getting it wrong.
You said something earlier in the conversation, Simon, about speaking to your clients now. I feel like there's a huge opportunity to use this topic to get face-to-face with clients, educate them, add value. My worry would be that, and I know you said like you need to educate your staff, but how do recruiters go about that? How do they explain some of this stuff? Firstly, how do they go and understand it? Yeah. And then how do they go and give that information to someone else in real basic layman's terms? Because I worked in the construction industry doing recruitment for a long time. I think trying to go and explain this to someone that's maybe just not that way inclined.
It's really difficult, isn't it? Especially those changes to 0 hours contracts. Really tough trying to explain that to a client. I think there's a number of pieces of advice I've been giving to people over the time, which is don't believe everything you read on LinkedIn about this. There's lots and lots of misinformation out there about the changes to the employment rights changes and the umbrella changes. So you've got to be really careful about where you're getting your source of information from. Make sure that you come to events or go to events through people who are actually in the know about the changes. We run plenty of events. There will be other organisations that run events, but make sure it's a quality event. And try and get in front of your clients to talk to them about how it's going to change and open a dialogue as to what the changes look like and how you may then deal with those challenges. And if there's going to be questions that you as an agency do not know the answer to, get advice on those points. Ask one of the trade bodies, if you're a member of a trade body, for some help. They've got legal helplines available, the REC, APSCO, they have legal help available. To reach out. They will be producing resources to help you as an agency.
I think that's the thing, isn't it? I think often we avoid conversations because we don't know, we're worried about what questions might come up. But I think there's things when you and I were speaking off camera and you're like, we don't know the answers to that yet.
Yeah.
And so I think that's
absolutely.
With this, I think it's just...
I can't give you all the answers today as to how this is going to work. I can give you the nuts and bolts as to how it's going to work and things that you need to prepare for. Because once the changes start to happen come April, the changes will be relentless. And if you're not starting to get yourself in the mode now of what change is coming, when is it happening, what do I need to do to prepare for that, you're just going to be falling behind and behind and behind, whereas somebody else who is prepared and is talking to their clients, the client will think, that's great, they're talking to us about how these changes are going to work.
Have you got any thoughts on what to do if the client is maybe somewhat dismissive? So, do you know, it's 2027, kick that can down the road, don't worry about it now. We don't need to look at this. Is there? I don't want to scaremonger any clients into sitting down and having a conversation with us. But how would you advise your recruiters to deal with that, the recruiters that you work with?
The way I've dealt with this, and I've done a few events with agencies already now, where I've actually gone in and spoken to their clients. They've brought me in to speak to them, and I'm more than happy to do that with agencies. I think that's showing a good willingness, and that you as the agency have got some quality legal backing behind you, and to be able to explain how these changes work and the legal issues and the commercial issues that are going to come out of them, especially in relation to the changes to the 0 hours contracts legislation and things like SSP.
So just I suppose almost in summary, right? What should we be focusing on now, and what can we kick down the road a little bit? What's the things for late 2025, early 2026 that we should start to be putting into place and thinking about?
Definitely the statutory sick pay. That needs to be thought about, because that's a cost. They've talked about how much it's going to cost to businesses, and it's huge. Apparently these new changes will bring about over a million workers into focus of SSP who've never been entitled to SSP before. So I think that's the very first thing that people are starting to talk to me about and asking me questions about. So I would start to think about how you're going to get prepared for that, what policies that you are going to need in place, communications, making sure that workers understand how it is going to work. Wouldn't start rushing in, but it definitely needs to be thought about. April 2026 is actually not that far away.
Where do you expect the first sort of tests to show up with it? Like, are we going to see audits? Is it going to be people getting fined or sued, or employment tribunals? Like, how do you expect this to play out?
Yeah, so one of the things that will come about from April is they're introducing this body called the Fair Work Agency, which will bring together lots of different functions, things like the Gangmasters Licensing and Abuse Authority, the Employment Agency Standards Inspectorate. Things like that are going to be brought all under one roof. And they're going to start with that from April 2026. And they've brought in Matthew Taylor, who did the Good Work Plan, to oversee this. And one of the biggest things that this body is going to have to do is to enforce things and bring tribunal claims in relation to things like statutory sick pay. So if you think about it at the minute, lots of agencies may take risks in relation to, or not just agencies, businesses take risks on certain things, and maybe they get away with one tribunal claim. But now this body will have the ability to bring claims on behalf of workers. That's huge, massive change, a body that can bring claims in respect of workers where people haven't been paid things like sick pay properly, holiday pay properly. So I would say, in terms of one of the first things that we may see under these changes to the legislation, is we may see them looking for that very first case to make a headline to say, you know, that business that didn't do this properly, well, we're going to bring a claim on behalf of all of these workers.
Yeah.
Because you think about the costs out there of bringing claims, people not understanding how to access claims.
This has just got like the no win, no fee written all over it, isn't it?
And you don't even need to go to a lawyer for that.
Yeah.
But yeah, you can see in relation to things like sick pay that isn't paid properly. This body having the ability to bring those claims is quite significant if you're not paying people sick pay properly.
Wow, so big changes afoot, like you said, the biggest change for 30 years. If anyone's listening to this and just going, this is not my bag, I need some help, support with this, how would they best get in touch with you? Yeah,
just reach out to me on LinkedIn. I'm always happy to have a chat with somebody and see if I can help. That's the whole purpose of this, is to see if there is support that businesses need out there, and I'll desperately point them in the right direction. And if you want to engage me, all the better.
Brilliant, Simon. Thank you so much for your time today. This has been it's an absolute minefield, but it's one that I think we, as an industry, we have no choice but to explore.
Thank you very much. Thanks for having me.